Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I have to say I'm not much of a fan of unions. Not so much because I think unions are inherently bad or anything, it's just that for the most part, when I worked in healthcare, unions did a lot more harm than they did good. And by that I mean they segmented the workforce into unionized versus non-unionized. You have multiple bargaining sectors inside of a hospital, and administratively it increased costs and it didn't really provide that big of a benefit to the individual employees. But in places that, manufacture cars and do other things like that, I think unions often do a very good job. Unions also are not very popular down in the South where I live right now, and you sometimes see plants that would benefit perhaps from unionization, like mills, basically not having anything to do with them, moving as far away from them as possible, because they understand that unions sometimes cause the loss of jobs instead of the protection of jobs. So it's a little bit of a yin and yang thing. You can have good unions, you can have bad unions, and I don't really take a position one way or the other. But that's my bias, and I feel like it's important to start this video with my bias. I'm just not a big fan. Today we have a discussion about a Supreme Court case involving, I guess, pretty much everyone's favorite coffee company, Starbucks. Now, I have my very own Starbucks mug, right? Just here to drink coffee with. And of course, this afternoon I'm drinking water because if I drank coffee, I wouldn't be able to finish the video before I'd have to run to the restroom. But be that as it may, I do enjoy an occasional cup of Starbucks coffee, although generally it seems to be a lot stronger and a lot more acidic than most other coffees that I buy. And so as a result, I make my coffee at home. I just use a Starbucks mug and pretend. But today's video pertains to a case that made it all the way up to the Supreme Court that originated with Starbucks. And it involves the National Labor Relations Board. Now, I've done videos before about the National Labor Relations Board and how the N.L.R.B does not just protect unionized employees, they protect all employees, and especially the right to concerted action, where employees get together to change or affect their working conditions. There is some protection associated with that under the National Labor Relations Act. So I've done videos on that before. This particular video, however, originates from a unique situation, and let's take a look at that now. This is Starbucks Corporation versus McKinney, Regional Director of Region 15 of the N.L.R.B. for and on behalf of the National Labor Relations Board, and it's certiorari from the Sixth Circuit. After several Starbucks employees announced plans to unionize, they invited a news crew from a local television station to visit the store after hours to promote their unionizing effort. Starbucks fired multiple employees involved with the media event for violating company policy. The National Labor Relations Board filed an administrative complaint against Starbucks, alleging that it engaged in an unfair labor practice. Essentially, it's a National Labor Relations unfair practice if you engage in tactics that are designed to thwart unionizing efforts instead of advance some actual legitimate interest on behalf of the corporate employer. So they made this an unfair labor practice allegation, and the regional director then filed a petition under Section 10J of the National Labor Relations Act in the district court seeking a preliminary injunction for the duration of the administrative proceedings that would, among other things, require Starbucks to reinstate the fired employees. The district court assessed whether the board was entitled to a preliminary injunction by applying a two-part test that asks whether there is reasonable cause to believe that unfair labor practices have occurred and whether injunctive relief is just and proper. Applying this standard, the district court granted the injunction and the Sixth Circuit affirmed. So one of the chief roles of the Supreme Court is to sort of go after the lost sheep. Every now and then, the district courts and the circuit courts go off on a frolicking detour of their own and decide that the law in their circuit is going to be a little different than what the Supreme Court said. You see that a lot in Second Amendment cases, but you also see it here where they're applying a completely different standard for the issuance of an injunction. And the Supreme Court took this case for a reason. They always take cases for a reason. And essentially, they slapped down the Sixth Circuit. Let's take a look. When considering the NLRB's request for a preliminary injunction under 10J, district courts must apply the traditional 4 factors articulated in Winter versus National Resource Defense Council. So that's a Sentinel case that deals with preliminary injunctions. Said Section 10J authorizes a federal district court to grant such temporary relief as it deems just and proper during the pendency of a board's administrative proceedings. When Congress empowers courts to grant equitable relief, there is a strong presumption that courts will exercise that authority in the manner consistent with traditional principles of equity. For preliminary injunctions, the 4 criteria identified in Winter encompass the relevant equitable principles. So equity, of course, rooted in fairness, and you have to balance the factors in order to reach the right result. Nothing in Section 10J displaces the presumption that those traditional principles govern. The traditional rule is that a plaintiff seeking a preliminary injunction must make a clear showing that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that the injunction is in the public interest. These commonplace considerations applicable to cases in which injunctions are brought in federal courts reflect a practice with a background of several hundred years of history. Because again, equity came into the United States law when we broke away from England. We imported the law and the equity jurisprudence from England as part of our laws and jurisprudence. When interpreting a statute that authorizes federal courts to grant preliminary injunctions, the court does not lightly assume that Congress has intended to depart from established principles. Absent a clear command from Congress, then, courts must adhere to the traditional 4-factor test articulated in Winter. Section 10J's statutory directive to grant injunctive relief when the court deems it just and proper does not jettison the normal equitable rules. It simply invokes the discretion that courts have traditionally exercised when faced with requests for equitable relief. Further, the text bears no resemblance to the language that Congress has employed when it has altered the normal equitable rules. So the board argues that the statutory context requires district courts evaluating 10J petitions to apply the traditional criteria in a less exacting way, consistent with the Sixth Circuit's reasonable cause standard. But the reasonable cause standard goes far beyond simply fine-tuning the traditional criteria to a 10J context. It substantially lowers the bar for securing a preliminary injunction by requiring courts to yield to the board's preliminary view of the facts, law, and equities. Under the traditional standard, for example, the board would have to make a clear showing that it is likely to succeed on the merits. By contrast, the board may obtain a 10J injunction under the reasonable cause standard by merely showing reasonable cause to believe that unfair labor practices have occurred. Section 10J's statutory context does not compel this watered-down approach to equity. Now, how did we get here? Well, the National Labor Relations Board is an administrative agency, and it has its own fact-finding and administrative law judges that decide cases. So, for example, when they file an unfair labor practice complaint against a corporation, the administrative law judge that decides the case comes from the National Labor Relations Board. And I had a case probably 20 years ago in front of the N.L.R.B. I took that case all the way up to the 8th Circuit Court of Appeals in St. Louis, where, of course, appeals go to die. And as a result, they pretty much just rubber stamped the National Labor Relations Board. But think about it this way. Where do you go when you are dealing with an agency whose job it is to protect workers, and you believe you have a legitimate reason for having done what you've done, and unfortunately, the judge doesn't believe that any corporate policy has any weight or merit? The fact finding and the litigation at that hearing that I went to for the National Labor Relations Board was so grievously stacked against the employer that literally there was no way to win. This was an employee who violated numerous work rules and who, for whatever reason, decided that she was going to go around and cause trouble within the organization, saying things differently about different people. And essentially, they'd had enough. They fired her. She went to the National Labor Relations Board, and they decided that since she was in favor of unionization and she'd talked about unionization, that it had to be because of the unionization, not because of the bad conduct. It was a disastrously bad opinion from the N.L.R.B. and an even worse and more disastrously bad opinion from the Eighth Circuit. And I'm still mad about it. But the bottom line is, this is an administrative agency that is really out of bounds, out of control. They get to make their own rules and they get to enforce their own rules. And in a situation like this, Starbucks is actually very lucky that the Supreme Court took this case, because many times they do not. And the circuit courts of appeal do act very deferentially to these administrative agencies. Now, maybe that's good for certain employees, but in most cases, it's not good for essentially balancing the equities, because the people who are doing the balancing, let's just say the scale is way out of alignment. And as a result of that, a lot of times the employer can't do anything right. It is not, in my opinion, it's not a very fair system. But the Supreme Court here says, now wait a minute, you don't get to just waltz into federal court and get an injunction. You have to meet all of these standards. So when a court issues a preliminary injunction, the first thing they look at is the party going to prevail on the merits? And there has to be at least a substantial likelihood that that's going to be the case. So, for example, when two corporations have a confidentiality agreement in between the two of them over a particular subject, for example, the trademark or the formula for a particular drug, and one of them violates that confidentiality agreement and starts doing things that will cause the other company irreparable harm, well, all they have to do is show that they have a substantial likelihood of being able to enforce that confidentiality agreement. And as long as that confidentiality agreement is clear and to the point, there's a pretty good chance they'll prevail on it. That tips the balances in favor of the person seeking the injunction. But sometimes, because there is a four-part test, the injunction has to be in the public interest. So, for example, if the confidentiality related to severe reactions to perhaps to a vaccine or a medicine, those kinds of things are in the public interest. It is in the public interest to get that out, to disseminate information, transparency and all that, sunshine being the best disinfectant. And as a result, many times that will tip the balance of equities the other way, and you're going to have to wait to get a decision on the merits before you decide whether or not there is actually an injunction that will issue. It's a very interesting area of the law. It depends a great deal on the skill of the attorney and the orator who goes to argue the case in front of the judge. It depends a lot on the facts. It's usually very factually specific. And injunctions are, once they are in place, they are very hard to kick out. And the fact that the Supreme Court here did just that and said, look, you have to apply the actual test, not some made-up test that you are importing from the words of a statute that traditionally doesn't apply in the equitable context. So it's a good decision. It's a decision that, in essence, favored the employer, but it's also worth looking at who decided this opinion. This is the last page of the syllabus, and it says the board also reasons that district courts should apply a deferential standard because the board's final decisions are reviewed deferentially by a court of appeals. But the views advanced in a 10J petition are preliminary and do not represent the board's formal position. Deference to what is nothing more than an agency's convenient litigation position is entirely inappropriate. That's Bowen versus Georgetown University Hospital. The board's attempt to salvage the reasonable cause standard using statutory context thus fails. So, who decided this case? Well, again, Judge Thomas is delivering the opinion of the court. Roberts, Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, and Barrett all joined the opinion, and Judge Jackson filed an opinion concurring in part, dissenting in part, and concurring in the judgment. So this is one of those where everybody agrees pretty much that you need to apply a equitable standard to injunctive relief, and that's a good decision, I think. That's what I have for you today. If you have any questions, drop them in the comments down below, or you can always email me at the address above. Thank you so much for watching. If you have the opportunity, please do something nice for somebody today, and then when you get done, come on back down here tomorrow and join me at the beach, and we'll think about something else that's fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.